It's obvious. Public interest litigation is an effective tool if well utilized. And when I say well utilized, it's not just about the lawyers who come as counsel to the courts, but even for the judges who sit as judges or members of the bench on the other side. So it is something that both the lawyers and the judges need to appraise themselves of and keep the discourse going. Otherwise, if the lawyers are so abreast with issues public interest litigation and the judges are not, there's a hitch. In the same way, if lawyers come in and they are not when judges are, there'll be a hitch. So it is a two-way traffic. Both the judges and the lawyers need to appraise themselves of this process called public interest litigation.
To engage successfully in this exercise, it is important to choose individuals that will stand with you throughout the case. But you also need people who will attract sympathy. If you're going to get a notorious, somebody the public perceives as notorious, imagine yourself trying to challenge a law, and somehow Joseph Kony is back in the Republic and is the petitioner. You see, people look at Joseph Kony, they will not look at the cause he or she is championing in public interest.
Strategic interest litigation is a very, very creative way of bringing about broad change. Now, when would one choose to use strategic interest litigation? First and foremost, you'll have to consider all the factual, the legal and the tactical issues, and then decide whether it is strategic interest litigation that you're going to. My Lord just stated that when you're trying to push down this wall, start by edging out a brick. Yes, there are instances where you may actually have only one litigant, but the end result, the favorable judgment, is going to actually assist a whole, a whole community, or it will then open, yes, the door for other litigants to come on board.
There is no single customary law for all Ugandans. So to bring a case and say the customary law of Uganda of bride price should be unconstitutional, which one? Now you end up only bringing evidence regarding Tororo women. I would have said bride price among the Japadola of this. Then I pursue that as something I know, and then get it annulled within that community, because that custom is different from the custom in Busoga, is different from the custom in Ankole, is different from the custom elsewhere. So that is a problem. You go somewhere and everybody thinks all black people in Africa are the same and they all speak one language. No. So that was a strategic problem. How can we get over this? Education. I've told you, number one, education. Number two, education. Number three, education.
I want to agree that if women in their struggles, they are rude and insult men, that is wrong. Because in the first place, it is men who hold the authority. They have the instruments. They have the authority in terms of power, finances, resources, and the usual authority which I don't know who gave to them, but which they have. And so for us to want to recapture and share together, we must be very, very strategic, we must be very tactful, and we must be convincing.
Do you actually believe that media has a role to play in public interest litigation? And what would be your understanding of that role before we go into trying to understand or how media has played this role over time?
The most important thing for any journalist for any media practitioner is freedom of expression. And I'm not using the word freedom of the press because with the advent of technology, with so many people on WhatsApp, on social media, so to speak, when you said the freedom of the press, then we traditional journalists or we people who went to J school, we are attempting to define journalism in our own prism of I went to journalism school, so whoever didn't go there is not a journalist. So freedom of expression then takes care of the guys on social media, the guys on Twitter and all that. If we do not give freedom of expression, then you can't have a media or journalists achieving or doing their role in public litigation.
So it is important that as we develop and nurture the interest in public interest litigation, that we continue to build better understanding between the media institutions and litigation processes and courts, and to see ourselves not as adversaries, because there are times when courts and lawyers and the public view the media as a nuisance. It is not, because when you work with the media well, you can oil the process, you can oil the wheels that will make a matter of public interest in the courts of law